government by rules either remove Chief Election Commissioner except by impeachment in the manner provided for removal of a judge of the Supreme Court, nor the Parliament can make law, nor the government or rule vary conditions of service of Chief Election Commissioner. The proviso to Article 325 operates as a singular insulation to protect the Chief Election Commissioner either from being arbitrarily removed or his conditions of service being varied to it. But as contemplated by the founding fathers, the protection against arbitrary removal or protection against varying conditions of his appointment were not sole safeguard so far as far more vital was the appointment of the right man and the need to take out of the exclusive hands of the executive. But this is what the ratio of the judgment is, my lord. I'm just submitting. And now, Lordship, may kindly come to para 106, my lord, which is page 196. It deals with the cases regarding separation of power and judicial activism. And at para 111, page 197, separation of power has been held to be a basic structure of the Constitution. Page 111, Indira Nehru Gandhi is quoted, the principle of separation of power is not a magic formula for keeping the three organs. 112 is important, my lord. Separation of power is understood as prevailing in India, constitutes a part of the basic structure of the Constitution of India, see Keshavanand Bharti. Then Indian Aluminium, adjudication of the rights of the party is an essential judicial function. Now, my lord, I will show to your lordship, my lord, the Election Commission exercise varied judicial powers also, my lord. So it has to be an independent person completely, and the appointment process has to be independent. The adjudication of rights of the party is an essential judicial function. The legislature has to lay down the norms and conduct of the rules which will govern the parties, and transactions require the court to give effect. Now, Roman 4, subpara 4 of para 56, courts in their concern and endeavor to preserve judicial power equally must be guarded to maintain the delicate balance devised by the Constitution between three sovereign organs functionaries, in order that they know that the rule of law permits to fulfill the constitutional obligations of establishing an egalitarian society, respective sovereign functions, etc., etc. Lordship may skip over that part, my lord. Lordship may kindly come to page 198, para 116. Separation of power is a part of basic structure of the Constitution. Equally, judicial review has been recognized as a form of part of basic structure. Judicial review of a legislation is expressly provided in Article 13. A court, when it declares a law by legislation unconstitutional, if it be that it is within its bound, cannot be accused of transgressing the principle of separation of power. Declaration of a law made by the Parliament as unconstitutional form part of its power. In view of the enunciation of the doctrine of basic structure in India, unlike perhaps in most countries, even an enactment to the Constitution can be declared as unconstitutional by the court. Such exercise cannot expose the court to the charge that it is not observing the limits of the Constitution. Then Lordship may skip over regarding judicial review. Lordship may kindly come to para 186, my lord. Page 224. Para 186. My lord, what is important is that the court noted in Anukul that holding free and fair election constitute a basic feature of the Constitution, and approved of the view apparently that the right to elect is fundamental to the democracy. Even a treated as statutory right, at any rate, cannot be divulged from or separated from the mandate of 326. The right is of the greatest importance and form the foundation of a free and fair election, which in turn constitutes the right of the people to elect representatives. We would, for the purpose, list the question rest here to process said. Then democracy, my lord, Dr. Ambedkar's speech is quoted, my lord. I have read to your lordship that, and lordship may kindly come to para 200, my lord, at page 229. Article 324 is a plenary provision clothing the article Constitution Election Commission with the entire responsibility to hold national and state election and carries with it the necessary power to discharge its functions. However, the Law Commission cannot act against a law framed by the Parliament or state legislature. The power of the Commission is also subject to the norms of fairness and it cannot act arbitrarily. The action cannot be mala fide. Article 324 governs in the matters not covered by legislation. Being a high constitutional functionary, which is expected to function fairly, legally, if he does otherwise, the court can veto the illegal action. See Mohinder Singh Gill. Now, my lord, 201. Election Commission under 324 can postpone election on the basis of the opinion that there exist disturbed conditions by the state in the state or some area of the state, thus making of holding free and fair election not possible. This court followed Mohinder Singh Gill in democracy depends upon the man as much as the constitution. Election Commission is endowed with the power to recognize political party, to decide disputes arising from them. It can also adjudicate controversies or splinter groups within a political party. The right, this is where the judicial power comes, my lord. I'll show to your lordship later. The commission has also been found to have power of issue of symbol order. This right is traced to Article 324. Then, recognizing the magnitude of exercise of control is fair in election, this court declared that in case of conflict of opinion, the opinion between Election Commission and the government, as education of machinery to deal with the state of law and order, assessment of Election Commission was to prima facie prevail. This court no doubt observed that mutually acceptable conditions so and so. While dealing with the power of the Election Commission to the requisite staff for election duty, disagreeing with the Commission, it could require the service of the employee of the Bank of India. This court declared the Election Commission did not have untrammeled power. The power must be traced to the Constitution. Election Commission has the power to issue directions to conduct elections, requiring the political party to submit details of the expenses incurred or authorized by them for the purpose of election of their respective candidates. The power was traced to the conduct of election. All the powers of election, though not specially provided but necessary for effectively holding elections, are available to the Election Commission. So 324 is the reservoir of power. Now, lordship may kindly come to my lord para 207. From a spate of violence in the state of Gujarat in the dissolution of assembly, the commission took the view that it will not be possible to hold election, though 174 mandated there shall not be more than 6 months between. After finding that 174 did not apply to the dissolved assembly, it was indeed held that this court reiterated the words that superintendence, direction, and control and conduct of election were the broadest term. This court also found that there are no free and fair election. This is the end of democracy. Now, my lord, this is on the width of the power of the Election Commission. Lord, I have a separate chart, my lord. I'll invite your lordship's attention to that. Would your lordship now kindly come, my lord, para 213. 213. And 214, it's very, very important, my lord. To page 233, para 213. We would therefore find that the Election Commission of India has been charged with the duty and blessed with extraordinary power to hold elections to both Parliament and the state legislature from time to time. This is an enormous task. The power it possesses under Article 324 is plenary. It is only subject to any law made by the Parliament or by the state legislature. Undoubtedly, the Election Commission is duty-bound to act in a fair and legal manner. It must observe that the provisions of the Constitution abide by the direction of the court. The same being done, it can draw upon a nearly infinite power of the reservoir power of power. Once a poll is notified, which again can be called to be taken by the Election Commission itself and indeed capable of being misused and subject to considerable controversy if bias, subservience of the power, that is betrayal, it assumed unusual powers. Its writ lies across the government over the length and breadth of the country. Officers of the government who come under it charge become the subject to the superintendence of the commission. The fate of the political parties, its candidates, and therefore the democracy itself, to a great measure, is allowed to rest in the hands of the Election Commission. We may therefore be the officers, while there may be officers who assist the commission, virtually important decisions has to be taken by those at the helm of affairs. It is the Chief Election Commissioner or Election Commission at whose table the buck must stop. It is in this scenario we bear in mind that when a decision is taken in the process of holding the poll, that's subject to proceedings which are initiated in the court, which conduce to the effective holding of the poll. Any proceedings which seeks to bring the election process under a shadow of taboo. The significance of this aspect is that it adds to the enormity of powers of the responsive to election commission. Awaiting outcome of the poll and to question the election commission before the tribunal may result in illegal, unfair and malafide decision of the election commission passing under the muster of the day. Once the elections results are out, the matter is largely reduced to a fait accompli. In fact, at many a times, an omission or a delay in taking decision can itself be fatal to the holding of free and fair election. The relief vouched in an election petition may not by itself provide a just solution to the conduct of election in an illegal, malafide or unfair manner. These observations have a direct connect with the question which are concerned, namely, the need to take an appointment of the members of the election commission out of exclusive hands of the executive, namely the party which are not unnaturally has an interest in perpetuating its power in itself. So that is the question posed, my lord. And lordship would kindly now come to my lord. Para 206 is not necessary. That's all that we can go on reading it.
And unrelated abuse, shows critical of democracy.
That's all. Para 220, my lord. Equally, the startling questions which we have described, which must be possessed by the Election Commission, is an indispensable for an unquestionable adherence to the guarantee of equality under Article 14. The wide spectrum of powers the Election Commission exercise them unfairly or illegally, as much as it refuses to exercise power. When such exercise becomes a duty, it has a telling and chilling effect on the fortunes of the political parties. Inequality in the terms of matter of treatment of political parties who are otherwise similarly circumscribed, unquestionably balanced, so and so. Political parties must be viewed as an organization representing the hopes and aspirations of its constituents who are citizens. Lordship may ignore, my lord, this part of it, although. Then Lordship may kindly come to, my lord, that there is a power under the symbol order. And, my lord, Lordship may straight away come to para 248. 222. Sorry. Yes, I'm so sorry. I missed one para. Para 222. That's it. Page 236, my lord. Para 222. The Election Commission, including Chief Election Commissioner, blessed with infinite power and who are able to abide by the fundamental right, must be chosen not by the executive exclusively and particularly without any objective yardstick. Lord, this is the ratio of the judgment. They are reiterated in further paragraphs, my lord. So it is very clear, my lord, it cannot be chosen by the executive exclusively and without any objective yardstick. Now, Lordship may kindly come to, my lord.
The answer is just one moment.
Yes.
Please come to 146.
146, my lord. Page 146.
Starting page of the judgment.
Yes, my lord.
Para 3.
Yes, my lord.
I'm
Yeah.
looking at prayer 1
Yes, my lord.
of WP Civil 104.
Yes, my lord. May I read that?
Which was the lead petition.
Yes. Mandam.
Prayer 1,
Yes.
and you will have to answer.
Yes.
Or you will have to show us from the judgment
Yes, my lord.
why this prayer was not granted.
May I just read
If
the
this prayer
prayer?
had been granted, that would have been the end of the matter.
Please, your lordship. May I just read this, my lord? Issue a writ of mandamus, an appropriate direction or order, directing, commanding the respondent to make a law ensuring fair and transparent process for selecting by constituting a neutral and independent collegium selection to recommend the name of the appointment of election commissioner of the Constitution of India. What
So if
prayer
you
is,
read
my lord?
this prayer with 222,
Yes, my lord.
why did the court stop at?
Lord, it says it is a neutral and independent collegium selection committee. Neutral, independent collegium.
Once it is said in 222
Please, your lordship, my lord.
that the
It cannot be left.
collegium should not be
Yes,
comprised of persons.
yes. Of executive exclusive.
Because the election commissioners have to be chosen not by the executive exclusively.
Please, your lordship, my lord.
Right. So why did the court stop?
No, it has gone further, my lord. I'll show
So
to you.
that you have to
I'll
What is the reason just show?
Yes, yes, my
that
lord.
paragraph.
Yes, my lord.
You stop holding.
301.
48.
Yes.
Independence. Independence the meaning है. 248.
Page 245. Concept, independence. Yes. Independence and sterling and indispensable attribute. What the prayer is, my lord, that it must be neutral and independent collegium. That is what is expected, and what the 222 said, it cannot be executive alone. And further discussion is here, my lord. 248 onwards, my lord. I may have, yes, para 248, page 245. Yes. What is independence? Independence is a value which is one of the elements in an amalgam of virtues that a person should possess. The competence of a man is not to be in conflict with fierce independence. A person may be excellent, that is, at his chosen vocation. He may be excellent administrator, he may be honest, but the quality of independence transcends the contours of qualities of professional excellence as to the dictates of the honesty. We may no doubt clarify that ordinarily honesty would embrace the quality of courage, of conviction flowing from perception of what is right and what is wrong, irrespective of consequences to the individual. An honest person would ordinarily be unrelenting, take on high and mighty, preserve his righteous path. An election commission is answerable to the nation. The people of the country look forward to him so that the democracy is always preserved and fostered. We may qualify the above observations by stating that true independence of a body of persons is not to be confused with sheer unilateralism. This means that the election commission must act within the constitutional framework and the laws. It cannot transgress the mandate of either and still claim to be independent. Riding on the horse of independence, it cannot act in an unfair manner. Now, independence must be related finally to the question, what is right and what is wrong. A person who is weak need before the powers that it cannot be appointed as an election commission. A person who is in the state of obligation or feels indebted to one who appointed him fails the nation and can have no place in the conduct of election, forming the very foundation of democracy. This is the answer, my lord. What your lordships have laid down the guideline, my lord, that you cannot leave it to the person, my lord, who will appoint him and then he feels obligation for his lifetime and he feels indebted. An independent person cannot be biased, holding scales openly even in the stormiest of times, not being servile to the powerful, but coming to the rescue of the weak and wrong, who is otherwise right, would qualify as true independence. This is the test, my lord, whether we have a system which selects a person who is not obliged to a person. 2251. Upholding the constitutional values which are in fact a part of the basic structure, which includes democracy, rule of law, right of equality, secularism, purity of election, otherwise would indeed proclaim the presence of independence. Independence must embrace the ability to be firm even against the highest. Not unnaturally, uncompromising, fearless will mark an independent person from those who will pull hold by holding their karma. In the context, we feel advised to refer to the following discussion, the AOR Association case, the 4 judges case. A little personal research would result in revelation that the concept of legitimate power of reciprocity debated by Benin in these articles, the basis of power and power of interaction model of so-and-so influence, in addition to having dealt with the very physiological regions which influence the personality of an individual, reference was also made to the legitimate power of reciprocity. It was pointed out that the reciprocity norm envisages that if someone does something beneficial for another, the recipient would feel an obligation to reciprocate. In view of the view expressed by the author, the inherent indeed of the power is universally available in the subconscious of the individual. On the satisfaction of the achievement of the desired power, there is a similar unconscious desire to reciprocate the power. It is important that the appointment must not be overshadowed by even a perception that a yes man will decide the fate of the democracy, that all it promises, certainly the darkest apprehension of the founding fathers, as buttressed by the reports and other materials, unrelentingly point to the impressive. So, Lord, this is what the independence means, my Lord. There should be no reciprocity, there is no obligation, there is no indebtedness. Further, my Lord, this court has further, in more clearer terms, has said in the subsequent paragraphs, which I can just refer to your Lordship, my Lord. Page 263. 263, para 301. Yes. May I read from 299, my Lord? Para 299, page 263. It may be true, my lords, about it, that the Election Commission of India provides its services to certain countries. That, however, does not deflect this court from providing what its founding fathers contemplated and also advocated in various reports. It may be true that the Election Commission of India were appointed for the 4 decades of the Republic, and thereafter, since the year 1993, Election Commission has become a team which consists of Chief Election Commissioner and 2 election commissioners, It may be true in the sense that the President, acting on the advice of the Prime Minister in accordance with the rules of business concern, has been making the appointment. However, it is equally clear that Article 324 has a unique background. The founding fathers clearly contemplated a law by Parliament and did not intend the executive exclusively calling the shot in the manner of appointment of the commission. This is what your lordships have found in the Constitution bench. 7 decades have passed by. Political dispensations are varying use, which have held the reign of power, have not unnaturally introduced a law. A law could not be one to perpetuate what is already permitted, namely appointment at an absolute and sole discretion of the executive. A law, as Mr. Gopal Singh Karnan pointed out, would have to be necessarily different. In the absence of such a law, does create a vacuum. This is despite the chorus of the voices, even cutting across the political divide, urging divesting of the exclusive executive of the appointment from the executive. We have noticed that the making of a law is ordinarily the power of the legislature. Lordship may exclude that. Come to 303. Political parties undoubtedly would appear to betray a special interest in not forthcoming the law. The reasons are not far to seek. There is a critically vital link between the independence of the Election Commission and the pursuit of power, a consolidation and perpetuation. As long as the party which is voted into power is concerned, there is not unnaturally a near insatiable quest to continue in this settle, a pliable election commission, an unfair and unbiased overseer of the fundamental exercise of adult franchisee, which lies at the heart of democracy, who obliges the power that be, perhaps offer the surest gateway to acquisition and retention of power. Lord, what can be the more blunt way of putting it, my Lord? That they have an interest. The values that animated of the freedom struggle has to be brought to the home by a new generation who has come to the inspiration relating to fundamental duties. Criminalization of politics, a huge surge in the influence of money power, the role, and Lordship would, when it criminalization of politics, my Lord, Lordship would note, my Lord, 40% of our lawmakers, be it parliament, be it the state legislature, have criminal cases.
26.
And this court, my Lord, despite taking various steps, my Lord, have not been able to reduce that number.
Not the subject matter.
Yes.
It's the practical subject.
Yes, my Lord, very well, my Lord, may I read it.
Tell us, after saying in various paragraphs the need
Yes, my
to
Lord.
exclude the executive, why is it said in 315?
Yes. Yes, Lordship would sign a final name, Lord, in 320, para
The
326.
court is laying down norms.
Yes.
Laying down norms for what? Appointment of
Appointment of,
election
yes,
commissioner?
yes, my Lord.
Why does court restrict it only for a particular period till the law is made?
The
The
till-
court could have
till-
stopped at 314.
Yes.
They are asking you, what was the reason that wait? in the
No, because there was no law at that point of time.
There was no
Really
law.
law is made.
There was no law.
Yes,
The
my lord.
court says that there is a necessity
Vacuum?
to bring in a law.
Yes, my lord.
The court is discussing, if you
Yeah.
see Mr. Ansaria,
Yes, my lord.
309.
Please, your lordships. 309. In a unique provision of persons who are concerned with the devastating effect of continuing to leave the appointment in the sole hand of the executive or fundamental values as the fundamental rights, as we are also considered of the time the right for the court to lay down the norms. In other words, the vacuum exists on the basis of that unlike other appointments, it was intended all throughout the appointment exclusively by the executive was by mere transit or stopgap arrangement. It was to be replaced by a law made by the parliament taking away. Now the law is to be, my lord, taking away the exclusive power of the executive. No, this is what your lordship has said. Whether the law meets this test, whether the law has taken
Therefore,
over,
the court finds that it is high time that norm should be laid down.
and it should not be in the hands of the executive alone.
So then why is it said in 315?
315, my lord. That the law will be made, my lord. But law has to be, such law has,
You say that the basis of the order of
Yeah.
the judgment
yes.
has to be removed, which has not been removed.
My lord.
That is what we find
No,
from
no,
your.
yes, my lord. Basis
So
of,
this judgment on its bare reading
Yes.
shows that it was only to deal with a particular situation of a vacuum.
yes, my lord. And how the vacuum is to be filled, my lord?
So tell us.
Guidelines are
how to
laid down.
extend it.
Please, your lord.
How do you extend it beyond
Yes.
the framing of the
Ye-
law?
yes.
That this has to be the norm and
It,
the
my lord,
parliament
yeah,
has no
yes.
discretion.
No, parliament has the discretion so long as it does not leave exclusively in the hand of the
Is
executive.
your sheet anchor?
Sorry, my lord.
This judgment is your sheet anchor.
Yes, my lord.
It
Yes.
says that Chief Justice should be there.
Yes. I'm not saying Chief Justice, my lord. There has to be, my lord. What I am saying is it cannot be with the hands of the executive exclusively. What the parliament does, my lord, there are various committee reports on various things. But it cannot be in the hands of the executive as Section 7 says. Section 7 says Prime Minister, a minister nominated by the Prime Minister and leader of opposition. Means, my lord, it is in the hands of the executive and executive alone. I'm not saying that lordship would issue a
We
mandate.
have the parliamentary debates which.
Yes, I have, my lord. I will show to you, lord.
Let us go to that.
It is in that.
Because it stops at till the law is made by the
yes,
parliament.
yes, my lord.
So what did the parliament consider? How was this judgment considered by the parliament?
Please, lordship, would your lordship permit me to place that, my lord? Just, my lord. May I read just two more paragraphs and then come to the constituent and the parliamentary debates, my lord? Para 301 and 3 by Justice, my lord, Justice Joseph. Yes. Yes. However, para 301, however, it is equally clear that 324 has a unique background. The founding fathers clearly contemplated a law and did not intend the executive exclusively calling the shots in the matter of appointment of. So, my lord, the law which your lordships had declared, such law made by the parliament cannot be, which gives exclusive power to the executive. It does not meet the test of this judgment. It does not meet the test, the ratio laid down by this, which is called out from the Constituent Assembly debates and the various reports of the before and after the Constituent Assembly. And similarly, my lord Justice Rastogi's view in para 353. Yes, yes. The Election Commission performs para
What
353.
was the final direction of the
Yes, my lord.
lead opinion?
Yes, my lord.
Where do we find it?
326, my lord. Para 326.
326.
Yes, Lord.
Elections are.
Page 270, final relief. We declare, may I read that as per the appointment to the post of Chief Election Commissioner and Election Commissioner are concerned, the same shall be done by the President on the advice tendered by a committee consisting of the Prime Minister, the Leader of Opposition in the Lok Sabha. In case there is no such leader, the leader of the largest single party in the opposition in Lok Sabha having the largest number, this norm will, and the Chief Justice of India. This norm will continue to hold good till a law is made by the Parliament. As regards the relief of putting the placement of permanent secretariat, etc., not very important.
Still the law is made by the.
Till the law, my lord, I'm not saying that law cannot be made, but such a law cannot be made, my lord, in the teeth of the other findings, which says it cannot be exclusively in the hands of the executive. My grievance is there, my lord, that the constitutional makers, as well as this court in Hon'ble has said, the appointment of the election commissioner or chief election commissioner cannot be in the hands of the executive alone. Now, whether this law, which has been made, has given the power to the executive completely, my lord, and it has, my lord, section 7 is, so it does not, my lord, satisfy the requirement of, my lord, the constitution or, my lord, as interpreted by our lordship, my lord, under the various paragraphs. And, my lord, what is the law now, my lord? What was earlier? Earlier it was, my lord, that the president makes on the aid and advice of the Council of Ministers. Now also, my lord, the president makes on the aid and advice of the Prime Minister and a minister chosen by the Prime Minister. There is no change in the position on the ground, my lord. The position remains the same.
No, Mr. Sansaria, if you come back to the prayers once again.
Yes, my lord, may I just come back to...
Commanding the respondent to make a law.
Yes, my lord. Make a law ensuring free...
Ensuring so and so.
Ensuring so and so.
Ensuring so and so.
Yes. And further, my lord.
Does the Supreme Court have the power to say to Parliament, make a law?
No, my lord, it has not, and it has not.
But the prayer was direct Parliament to make a law.
But
in the first place,
yes,
was this prayer maintainable?
My lord, it was not granted, my lord. I will not say no mandamus can be issued to the Parliament, my lord. The law is very clear. There's no mandamus some vacuum can be filled till a law is made, but that law has to be valid law. That's like, my lord, in PUCL and ADR case, other case I've separate. The mandamus was till a law is made, you must declare criminal antecedents, your assets and liabilities. Law is made, you don't need to declare. And that was struck down in PUCL case. Only on the ground that the basis of the judgment, you cannot undo it by legislation, so-called legislation, by retaining the same position. Lord, here also, the position remains the same. Prior to making of the law, it was the president who makes on the aid and advice of the Council of Ministers. In other it, Lord, para 5.
To assist Mr. Hansaria, my lords, para 308 refers to the mandamus point.
308.
Yes, my lords. 308 and 309.
My lord, may I read, my lord, para 5. There are batch of petitions. In one of the prayer, para 5, in writ petition so and so for ADR, issue appropriate direction order declaring the practice of appointment of CEC and EC solely by the executive as violative of 324 and Article 14. And that is what your lordship has done. And B, direct the respondent to implement an independent system of appointment of EC, etc. on the line of 255th report at Dinesh Goswami Committee report, etc., etc. And this is what your lordship has said. The various committees have said, my lord. Dinesh Goswami Committee report has said, the Law Commission report has said, my lord. It cannot be exclusively, my lord. Who can be? Parliament will take a call. But it cannot be, my lord, that the executive exclusively had it.
He answers the mandamus.
308, would your lordship kindly see the para
308.
Yes, Lord, as your lordship has said, my lord.
Prerogative of the Parliament.
Yes, my lord.
To enact the law.
Yes, my lord.
Courts cannot direct Parliament to make a law.
That prayer is rejected, my lord, in para 308, no doubt.
Now, for 7 decades,
yes,
324(5)
yes,
was on paper only.
Yes, my lord.
Court felt that it is high time
Yes.
that certain norms should be laid down.
Yes.
and these norms should be followed till such time a law is made. by the Parliament.
Please, your lordship.
Right? The court was conscious
Yes,
of its limitation.
yes, my lord.
So these observations which have been made over 300 paragraphs,
My lord.
are these not to be read
Yes.
as justification for why these norms are prescribed till a law is framed?
My lord, till a law is framed, it is, my lord, these norms have to be followed. But when a law is framed,
When a law is framed, then can you say that these norms have been followed,
Lord,
have not been followed?
Lord,
Therefore, the law is
no, no. These norms flow from the constitutional mandate. Lord, these norms, which are laid down by your lordship, Lord, in various paragraphs, are derived from the constitutional mandate that it cannot be left to the executive alone. That is the mandate of your lordship's court. That if it is left to the executive alone, there is a reciprocity, there is no independence. So you have to have an election commission which is independent. And if you leave it to the executive, the independence is compromised. That is, and if the present, my lord, if the present law which has been made, it is the same position. My lord, there is no difference whatsoever in my respectful submission between the law which was earlier prevailing, except that now it is a parliamentary legislation. Earlier, under the rules of business, it was being done under the same thing, my lord. Under the rules of business, there was no different. The president does it on the aid and advice of the Council of Ministers. And it is done instead of the entire Council of Ministers, the Prime Minister and a minister chosen by him recommends, and that has been made. There is no difference which has been there, my lord. The law which is made can be tested by our lordship, my lord, on the touchstone of Article 14 and 3 to my lord, and independence of election commission.
Very well. Proceed.
Yes, my lord. So, my lord, this is what has been held by our lordship, lord, that it cannot be in the executive alone, and then it is what has been done is by the executive alone. Para 353 only, lordship may note it. Justice Rastogi in the concurring view said the same thing, my lord. Now, my lord, lordship may see the parliamentary debates. I have put the parliamentary debates in volume 2, my lord, on this bill. Which starts from page 108 of volume 2. Yeah.
Second volume.
Second volume, my lord. Yes. Page 108 starts. At 110, the law minister presents it, and at 111, Randeep Singh Surjewala, it is in Hindi, my lord. May I read it in Hindi, my lord? I have to read it slowly.
$111.
111, Lord. Because the main opposition is by, my lord, speech is given by Randeep Singh Surjewala. It's in Hindi partly in English.
Well, will you read?
May I read it, my lord? सभापति महोदय, आदरणीय मंत्री जी ने कहा कि सुप्रीम कोर्ट ने कई निर्देश दिए हैं जिसकी चर्चा बाद में करेंगे। ठीक है, चुनाव आयोग को आधार प्रजातंत्र की शुचिता, प्रजातंत्र की निष्पक्षता है। संविधान डेमोक्रेसी जिसको हम प्रजातंत्र कहते हैं, उसका आधार ही निष्पक्ष चुनाव और निष्पक्ष चुनाव कराने वाली एजेंसी चुनाव आयोग है। आप जब भी आप चुनाव आयोग की बात करेंगे तो ये चार शब्द निष्पक्षता, निर्भीकता, स्वायत्तता, शुचिता आपके जहन में जरूर आएगी। सर, आप सभापति जी हैं और कानूनविद के तौर पर सुप्रीम कोर्ट के एक काबिल वकील भी हैं। 140 करोड़ लोगों के इस देश में किसी व्यक्ति के जहन में ये चार शब्द आएंगे। ये कानून है आज माननीय मंत्री जी और सरकार लेकर आई चार शब्दों को बुलडोजर करके बुलडोजर के नीचे कुचलने वाला कानून है। ये मेरा विनम्र आग्रह है। सभापति, इसके पहले मैं भी इसके प्रधान का चर्चा करूं। इंडिपेंडेंस ऑफ इलेक्शन, जिसे अंग्रेजी में कहते हैं अवॉइडेंस ऑफ इंटरफेरेंस ऑफ एग्जीक्यूटिव, हमारी इलेक्शन मशीनरी इन दोनों बातों से प्रेरित होगी। ये हमारे संविधान के निर्माताओं ने कहा था, काश आदरणीय कानून मंत्री जी मेरे, आपके और इस देश के लोगों के नहीं बल्कि जो बाबा साहब अम्बेडकर ने कहा था और संविधान सभा में जो चर्चा हुई थी उस पर एक नजर डाल लेते तो शायद ये कानून को अभी तक वापस ले लेते या बनाते ही नहीं अथवा लेकर ही नहीं आते।
What's the meaning of direct election?
हाँ, my lord.
Impartiality, and sanctity.
And
Sanctity.
sanctity. निष्पक्षता, independence, निर्विकता.
Fear.
Okay. Independence and
Sanctity.
sanctity. Now,
Which is the Hindi word?
Hindi word is nispakshata, nirvikata, nirvikta,
Nirbhikta means fearless.
fearless. I'm so sorry. Fearless, swayatata,
Independence and sanctity.
and suchita.
Sanctity. Independence and sanctity.
Yes. Now, would your lordship kindly come to my lord, page 114. Again, Mr. Surjewala, yes, it violates and negates the rigors and affirmation by the Constituent Assembly by Baba Saheb Ambedkar and other individual honorable members of the Constitution. It goes against the very spirit of the Constitution that it enriched in Article 14. It completely negates and subjugates the Election Commission to the authority of the executive. It does away with, and I respectfully say willingly, and if I say maliciously, the judgment of the Supreme Court in toto. That is why the law is per se like stillborn child. Thirdly, I want to point out, जैसा माननीय उच्च न्यायालय ने कहा, आर्टिकल 14 जो हमारे मौलिक अधिकार का हिस्सा है, जो सत्ता में बैठे हुए सत्ताधीशों के बेलगाम कार्यों पर अंकुश लगाने का सबसे बड़ा तरीका है, यह आर्बिट्रेरी पावर। यह पूरा कानून उस आर्टिकल 14 के लेटर इन स्पिरिट के विरुद्ध है, इसके मौलिक अधिकारों का उल्लंघन है। जैसा माननीय उच्च न्यायालय ने कहा, सभापति जी, अपॉइंटमेंट कमेटी है, अब एक एम्प्टी फॉर्मेलिटी है। इफ आई कैन यूज द वर्ड अपॉइंटमेंट कमेटी, क्या है? माननीय प्रधानमंत्री जी और माननीय प्रधानमंत्री के जो मनोनीत किए गए और उनके एक मंत्री हैं। गांव की एक कहावत है, क्योंकि ग्रामीण पृष्ठभूमि से हूं और आप भी हैं, आधा बांटे रेवड़ी मुंह, अंधा बांटे रेवड़ी मुंह में अपने को दे। Sorry, not used to reading Hindi. Yeah.
Blind.
Yes.
Andha means blind.
Andha blind.
Andha means blind. What is Bate Revri?
Please distribute the.
Please wait. Sir, you please tell us what is the meaning.
Well, I close my eyes. I'm giving it and I'm giving it to myself.
Man is distributing sweets. Reading here.
Distributing speech to person of
He closed his eyes, my lord, and give it to himself.
Oh, he's giving to his people.
yes, his people.
मूड कर अपने को दे,
Everybody is a small sweet.
अपने को दे, not अपनों को दे.
Say that andha means the blind person when he distributes. I don't know how far that is relevant because andha blind man cannot distribute to his own people because he would.
No, it's not in अपने को दे, not अपनों को दे नहीं, अपने को दे, खुद को दे.
So then he.
हाँ, he is giving it to himself.
So that's why saying
That's why it is the same. That is what the next line says. If the Prime Minister and his minister are going to be majority in the committee, then why have the committee? Then why have the committee?
He himself appropriates.
Yes.
That's the meaning.
And that is not the answer. If the Prime Minister and the minister are going to be the majority of the committee, एक JB or one pocket.
so you can continue.
Yeah. If the Prime Minister and his minister are going to be the majority of the committee, then why have the committee? Let the Prime Minister appoint everybody. Then why have even the law? It is an empty formality. Now, Lord, may I read last 3 lines? I am saying it with a sense of responsibility. For them, do not want an independent election commission, CEC or OC. They want a pocket borough उन्हें एक जेबी चुनाव आयोग, वन पॉकेट की आवश्यकता है। यह कानून एक जेबी चुनाव आयोग का गठन करेगा। आप जेब से चुनाव आयोग निकालेंगे और आप जब आप चाहेंगे जिस पर प्रजातंत्र के साथ वही करेगा। इस कानून का फाइनल मतलब यही है। यह पिक एंड चूज का फॉर्मूला होगा। सर, आई रेस्पेक्टफुली also say that it does not pass any kind of constitutional muster. We have to be aware. This is in August House. After all, we have to be aware as to what we see we are doing or saying and what we are passing. This is manifestly arbitrary. These are ill-conceived attempt. This law is ill-conceived attempt at the consolidating undue total executive control over the elected body, that is Election Commission. This process is arbitrary, intent is malicious, and result is disastrous, if I can say so. That is what going to happen, sir. And I want to take the liberty of last time quoting the Supreme Court judgment, then the Supreme Court judgment is quoted. And your Lordship may kindly come to my Lord, two more things. At page 119, sir, page 119, Lord. So,
Where is the SOR?
page 119.
Statements of reasons and objects.
Yes, my Lord.
SOR is there?
Bill, I don't think, my Lord, I have it. I'll just get it. I will just get it. Actually, not in my file.
We have separate trains.
Just Article 324 of our Constitution, second page of it.
Yes.
Envisages Election Commission of India to be an independent constitutional body vested with the superintendence, direction and control of the preparation of electoral roll and conduct all elections of parliament to the legislature of every state and of the elections of the office of the President and Vice President of India. In the Election Commission, the Supreme Court of India has in various landmark cases underlined the free and fair election to be part of the basic structure of our Constitution. In the Constituent Assembly debate, Dr. Ambedkar pointed out the election machinery should be out of the control of the government. So this is very important. The members of the Constituent Assembly agreed to leave the appointment mechanism to the ECI to the discretion of the Parliament, with unfolding of democratic process in independent improve the working of the Election Commission. To this extent, Goswami Committee, National Commission for Review of the Working of the Constitution, Law Commission, as well as the Election Commission of India has proposed. In 1991, the Parliament passed Election Commission Conditions of Service Election Transaction Bill. The Act sets salary of the Election Commission, the Election Commission at the same level as the Supreme Court judge. It did not provide for their appointment process, which continued to be decided by the President. In Anup Barnawal case, the Supreme Court declared that CEC and EC appointments should be independent of executive control and not done solely by the executive. It mandated a selection process which would hold until the Parliament makes a law. The court directed the appointment should be done by the President on the recommendation of a selection committee. The selection committee will consist of the Prime Minister, the Leader of Opposition and Chief Justice of India. The Election Commissioner and so bill was introduced in the Rajya Sabha on 10th so and assented by the in so and so. It repeals 1991 and provides for appointment process and conditions. The Act, however, has many issues, and the bill therefore seeks to amend this is the amendment bill of the terms and conditions with introduce the following changes to ensure that the suitable candidate, apart from the senior bureaucrat, also has an just a minute. I'm so sorry, my lord. Sorry. No, sorry. This is the amendment bill. I'm so sorry. This is the amendment bill, my lord. I'm so sorry. My line friend gave it to me. This is not what the objects and reasons of this bill. My mistake.
You can read
Can I?
You can read from here.
I'm so sorry, my lord. No, but I have to give it to my lord. This is some private. What happened to this? This is This is some private member bill. This is some. I'm so sorry. This was a private member bill. Not my mistake. I did not say it.
I have quoted in my agenda some part of it if you want to read it.
The
Just
objects
read
and
it.
reasons.
Yes.
It's full. Thing,
No,
but
no,
I'm
it's not full
just
with
This was a bill to amend.
Okay, can I read, my lord, slowly? There's a 2 paragraphs.
This bill is by
I don't have it.
Prabhu Patil,
Vishal Dada.
private member bill.
It's a private member bill. Sorry, my lord. That's what I thought, my lord. It could not have been, my lord, the bill. It was bill to amend, and this private. It was a private member bill, my lord. Lord, may I read slowly? That's just 2 paragraphs of that objects and reasons. The matter regarding conditions of service of the Chief Election Commissioner, other election commissioner, the procedure for transaction of business of election commission are presently governed by the 1991 Act. The said Act do not contain any provision regarding qualifications, search committee for preparing panel of persons for consideration and recommendation of selection committee for appointment as Chief Election Commissioner, other election commissioner, and other incidental provisions. The Honorable Supreme Court in Hon'ble declared that the appointment of CEC and EC shall be made by the President on the basis of the advice tendered by the committee consisting of the Prime Minister, Leader of Opposition, and the Chief Justice of India. It has been clarified that the aforesaid judgment that the said norm provided by the Supreme Court will continue to hold till a law is made by the Parliament. The proposed bill inter alia provides for defining various expressions in the bill: appointment, qualification, search committee, selection committee, term of office, salary, resignation, removal, pension of Chief Election Commission, Election Commission, and transaction of business for disposal. The bill seeks to achieve the aforesaid object. Well, that's all. But it does refer to the judgment of your lordship, Lord, in Hon'ble case. Lord, I was inviting your lordship's attention to the debates, my lord, just page 119, my lord, also.
Debates now,
Yeah.
after having gone through
Yes, my lord. Lord,
so much light.
all that it says, my
In
lord.
fact, I have been shown by my learned brother certain portions
Yes, my lord.
which leaves a very bitter taste in the mouth.
Yes, my lord.
They are of no help.
I'll not go. All that it says, my lord, that there is no change. Effectively, there is no change. It is the.
They are of no help to you.
Yes, my lord. Very well, Lord. I lordship wanted me to read this, Lord. I just read this. Now, my lord, I wanted to show to your lordship, my lord, from
A written submission.
in volume 1, my lord, the extent of power of the election commission. I have made a chart there, my lord. If your lordship come to volume 1, please.
Perhaps there is no dispute on that.
I'm so. Well,
Extent of powers of the Chief Election Commissioner
Yeah.
and the Election Commissioner,
Yeah.
there is no dispute.
no, but the length of power, my lord, it
You
is.
have already told us that they
If
decide.
I have tabulated it. If your lordship just permit me to just place it, my lord, hurriedly. I have tabulated certain. First, my lord, page 13 to 16, there are certain advisory powers
Right.
to the president. The page 13 to 16, there are advisory powers to the president, my lord, regarding disqualification, holding of office or profit, etc. Then similarly, my lord, in the RP Act, regarding delimitation also there are powers. My lord, what is important is, my lord, page 14, serial 5, disqualification on corrupt practice. If I can read, my lord, section 8A, even after disqualification, for what period it is to be on the advice of the Election Commission. So, my lord, it definitely depends, my lord. There are cases where, my lord, for corrupt practice, somebody is disqualified and his period is reduced to, my lord, 5 days, 10 days, he again becomes the chief minister. So that power is there with the election. I'm just going with the width of the power of the Election Commission.
Nobody is disputing that. Must realize that the Chief Election Commissioner cannot be removed from office.
Yes,
Except in the manner
yes.
a Supreme Court judge is.
Please, Lord, sir.
So that gives a clear indicator
Yes.
of
The
width of the power.
My lord, what I have
We need not labor on that.
No, all that your lordship may know, Lord. I have categorized them in 5 categories. There is advisory power, they have a legislative power, they have supervisory power, they have quasi-judicial power, and they have administrative power, my lord, which I have tabulated in this under 5 different heads, my lord. Because in the symbol order, my lord, they have very extensive power regarding symbol, disqualification, which party to be recognized splinter group and which party is not to be recognized as splinter group, my lord.
How long do you propose to take, Mr. Ansari?
Lord, I need to show to your lordship, Lord, that
When you ask for 1.5 hours.
yes. Because I need to show some so sorry. Very
Well, come back tomorrow. Let Mr. Gopal continue.
Very well.
Because otherwise,
I understand. He has
address tomorrow. Let us conclude with him.
yes, my lord.
Tomorrow you resume from where you are leaving today.
I'm grateful.
And please be precise.
Yes, my lord, I will be precise. I'm grateful to your lordship.
Yes, Mr.
My lords, I'm very grateful to your lordships as well as to my colleagues for permitting me the time which is theirs. I'll just be brief and I'll just explain what are the submissions I have to make. The first, to respond to your lordship's question about this directions in Anup Paranwal being till law is made. That was the direction that has been passed by your lordships in a series of cases wherever your lordships have found a vacuum. From the mid-1980s onwards, in Velo Citizens Forum, when your lordships found a vacuum with reference to environment, before the Environment Protection Act in 1986, the guidelines your lordships laid down under Article 32 and 142 was still a law is made. The idea was that we have a vacuum, we have international conventions that we are parties to, but to ensure that the Article 21 rights of the citizens are protected and taken care of till then, you will lay down guidelines which will be followed by all civil and judicial authorities under Article 144 until the law is made. The idea is the law will be consistent with what that judgment is. The same thing was followed throughout, and then in Vineet Narayan, my lords, if I can just read, I'll just read the exact language because it's the same language which is reproduced here. When we argued this matter before the Anup Paranwal bench, both Mr. Bhushan and I pointed out to the bench that one of the important aspects of the rule of law is that independent authorities have to be manned independently. The Supreme Court and its judges, the High Court and its judges, then investigating authorities like the CBI, the CBC, etc. And now with reference to the Election Commission. These 3 are the buckets in which 2 of them have that kind of independent appointment procedure, while the third doesn't. The first of that was in 1998 in Vineet Narayan's case, in which para 53, I'll just read para 53 of Vineet Narayan, I'm not going to take your time. It says, on this basis, we now proceed to give the directions enumerated hereafter for rigid compliance till such time as the legislature steps in to substitute them by proper legislation. These directions made under 32, read with Article 142, to implement the rule of law, wherein the concept of equality enshrined in Article 14 is embedded, have the force of law under Article 141, and by virtue of 144, it is the duty of all authorities, civil and judicial, to aid this court. Now, thereafter, in a series of judgments, including, as Mr. Hansaria rightly pointed out, with reference to the those who are contesting for elections, giving affidavits both of the assets and affidavits of their criminal backgrounds. That also came from first a judgment of the Bombay High Court, which was upheld by your lordships. They came with a judgment, they came with a law which implemented only one part of it. So then the court had to be approached again, saying, look, they have not removed the basis of the judgment. They have, using the same argument that they're likely to use today, saying it was until a law has to be made, they have made a law. But the question is, what kind of law can they make? Can they make any law which allows the executive to continue to have the exclusivity in the appointment? The answer resolutely by the Constitution bench is no. The question that can be put to us is, does it have to have the Chief Justice of the Supreme Court or Chief Justice of India or his nominee? The answer is no, it doesn't have to. It just needs a mechanism where the executive is not exclusively in control. This is an interpretation of Article 324 of the Constitution. It is for the constitutional scheme and to sustain Article 21. The only way that this can be gone around is by amending the Constitution. And let me give you an example, my lords. The collegium system came in by way of judgments of your lordships in Scora and then in the 1998 special reference. That judgment, the parliament, that legislation could not go around it. A simple law would not take care of the situation. Therefore, when they had to bring in the NJAC, it had to be by an amendment to the Constitution. They knew full well. I asked myself, if they brought in a law like the NJAC without the constitutional amendment, what would this court have done? My view is that this court would have no option but to say you have not removed the basis. What I've done is I've interpreted the provisions of the Constitution which deal with appointments to the High Courts and the Supreme Court. I've provided for a collegium system. We have provided that concurrence is what consultation will be read as. Now, if they had to go around that, the only way was by amending the Constitution. So that is not what they have done. So my first proposition, my lords, for your lordship's consideration is, if they have not amended the Constitution, and this Constitution bench has given an unanimous judgment referring to Article 324 and rule of law and saying that the executive cannot have exclusivity in selection, without a constitutional amendment, this law cannot stand. That is submission number one. Submission number two is that if you see the flow of the entire judgment, fortunately, my lords, there's an entire contents page in the Anup Paranwal judgment, which shows you what the breakup is. And I think that is critical because it shows all the various aspects that have been considered by the judgment. After taking our submissions into consideration, from para 16 onwards, the court takes the draft constitution and the Constituent Assembly debates. That paragraph of Dr. Ambedkar's, my lords, where he accepts and agrees with Mr. सक्सेना's submissions, in fact, concludes with the following words. If I can just read this to you, it's para 26 of Anup Paranwal, page 165. It says, therefore, in order to meet the criticism of my honorable friend, Professor Saxena, supported by the criticism of my honorable friend, Pandit Kunzru, I am prepared to make certain amendments in amendment number 99. I am sorry I did not have time to circulate these amendments, but when I read them in the House, when I read them, the House will know what I am proposing. The bench goes on to consider all of these aspects. It considers the effects of the Constituent Assembly debates. Your lordships may just take it as read in para 33, the effect of what the debate is and what the agreement by Dr. Ambedkar of Professor Shimalal Saksena's comment is laid down in para 33. They specifically refer at para 37.4 in page 169 that finally we find Dr. Ambedkar acknowledging the existence of a great deal of merit in the fear that guaranteeing a fixed and secure tenure was of no use if there was no provision in the Constitution which would stand in the way of either an incompetent or unfair official becoming and running the Election Commission. In particular, Dr. Ambedkar foresaw the danger of the election commissioners being persons who were likely to be under the control of the executive. So at every stage, after going through that, at para 38, the judgment at page 169 says that a golden thread, this is the phrase they use, runs through the entire proceedings of the Constituent Assembly. At para 50, they make the distinction between the Comptroller and Auditor General and the CEC because looking at the language that is employed in nearly 15 different provisions of the Constitution, this subject, until law is made, their provision is provided, which is what was there as far as the Election Commission is concerned. it's important to note, my lords, that in 1991, a law was made, but that law was only dealing with the service conditions. That's the issue that arose in the SS Dano and Seshan cases. And then, my lords, I thought one important fact is in para 309, 308 was read on the mandamus point, but at para 309, if I can read that, page 264, in the unique nature of the provision, we are concerned with and the devastating effect of continuing to leave appointments in the sole hands of the executive on fundamental values as also the fundamental rights. We are of the considered view that the time is ripe for the court to lay down norms. In other words, the vacuum exists on the basis that unlike other appointments, it was intended all throughout that appointment exclusively by the executive was to be a mere transient or stopgap arrangement, and it was to be replaced by a law made by Parliament, taking away the exclusive power of the executive. This conclusion is clear and inevitable, and the absence of law, even after 7 decades, points to the vacuum. Thereafter, my lords, from para 310 onwards, it is noted what are the norms that have to be laid down. And in conclusion, at 314 and then again at 326, they laid down that as far as the exclusivity of the executive is concerned, that is not something that should be entertained. The reason, my lords, that this second proposition of mine, the first is constitutional amendment absent, your law cannot stand. Second proposition is when the court has said that it was the intention from 1950 that you will not have the entire executive control over the appointment of the Election Commission, that should have been remedied in 1950 with a law. It didn't come. It didn't come for 7 decades. And that is why they say this stopgap arrangement has now become almost like a permanent structure for 75 years. They note elsewhere in the judgment, my lords, that no political party wants to upset this because when they have the reins in their hands, they want to control it. The opposition comes to power and they say, look, we will control the Election Commission like you controlled it for the last 2 decades. So the second point, therefore, is that the court notes in the background of this debate, in the background of the entire process that has gone on, and the role of the Election Commission, a role which the court extracts para and verse of judgment after judgment after judgment. Well, the court has been forced to step in, my lords, with reference to criminalization, with reference to assets, nota, a whole series of judgments which the court has had to step in because that void existed. Therefore, that stopgap arrangement, now having come to an end by the judgment in Anup Baranwal, this process that they've suggested in Section 7, my lords, does not in any way remove the basis. One last thing I want to tell your lordships is that the most recent example of this basis removal because of a judgment of the court came, if your lordships recall, in the Maratha reservation judgment. What happened is on the 15th of August 2018, the 102nd Amendment Act of the Constitution was passed. That made provision, my lords, in Articles 338 capital B and Articles 342 capital A for the Backward Classes Commission, which is given constitutional status, and for the lists to be prepared for the backward classes in the various states. Now, what those amendments failed to note was there will be a separate commission for states apart from the National Backward Classes Commission. So what happened is, by the wording of those 2 amendments coming in, is that it left it open without any clarity on what happens to the state commissions and said that lists for the purpose of this constitution will be the lists prepared by the National Backward Classes Commission. The effect of this is all the backward classes who existed in the country coming from the state lists cease to exist for the purpose of the constitution. That is in fact what the Maratha judgment in majority said. They said now that you have the 102nd Amendment, your state commission ceases to exist, your state lists cease to exist. To repair that situation, Parliament did not come back with a statute like they've done here. They amended the constitution again with the 105th Amendment, which came into effect on the 15th of September 21, barely 4 months after the Maratha judgment. And they brought amendments to both 342 capital A and 338 capital B. this was brought in the correct way. The only reason I'm mentioning this is because we have multiple examples, NJAC and this, are examples where when there is a judgment of the court and the basis has to be removed, when the court is looking at constitutional interpretation, you have to bring a constitutional amendment. I can understand if you're interpreting a statute. This is admittedly a case where there was no statute. In each of those cases, there are more than 30 judgments, my lords, where your lordships laid down guidelines and said until law is made, including Vishakha, sexual harassment. Those guidelines were laid down by your lordships following the Beijing Declaration. Imagine, my lords, if the parliament decided to come with a law which undid what those guidelines are. Clearly, your lordships would say, no, the spirit of our Article 21 interpretation was this, and you had to follow that spirit. That, my lords, is the entirety of my submission. I'm most grateful for the time your lordships have given me.
Tomorrow, Mr. Consent,
Please, Your Lordship.
you wanted the next week to respond? Maybe you will be taking the entire day tomorrow?
Yes, we'll conclude tomorrow.
I'll take about an hour, as I said.
Please conclude tomorrow, otherwise it becomes very difficult.
Tomorrow,
Very
we'll
difficult.
definitely conclude.
Can you just make a chart in case of appointment of which authority, constitutional authority?
Yes,
The CJI or his nominee has to be made.
I have a compilation. my
You
lord.
have a comparison.
I have a-
Start with that.
I'll hand it over.
My lords, it's there in Justice Rastogi's
Judgment it is there, but I have separately.
Para 444.
Acha.
Concurring, that chart is there. He
That
has
chart is there.
that chart.
Very
Yes.
Yes.
Para 444. We had given it to the court and it's been reproduced.
Yes.
Very-
In fact, yes.
So tomorrow,
After the fresh matter.
tomorrow we also have, my lord, 2 o'clock.
Can I respond next Wednesday? Next week, my lord, any fixed time, my lord. Other, my lord, they're at loggerheads, they're unnecessarily banging their head against their walls. The family, my lord, whatever your lord.
Any time, Mr.
I know, my lord, I know. That review petitions,
Please.
any one day, my lord, if you, 1 hour is the only slot I seek, my lord. I know that the board is jammed, my lord, and I'm fully, but they're fighting like cats and dogs. That's the only thing.
You asked for open hearing of the review. We granted.
No,
you.
we prayed, my lord,
We granted. you.
we prayed on
No.
Of course, my lord.
We granted it.
Right.
Yes, that
True.
was you.
I see.
It all depends on the
Yes, my lord.
gravity of the matter.
Yes, of course, my lord. Greatly.
Private parties fighting between each other.
Yeah, it's not new.
It's nothing new.
Greatly. Greatly.
Yes, judgment time. After noting the facts and the orders passed by the authorities, this is what we have said. We have found one little fault in your process. But at the same time, we have said that that fault does not change the nature of the misconduct that doctor had committed. Since it is apparent, we did not send it back to you. There was a misdeclaration in that form. So ultimately, this is what we have held. The order we propose to pass is not to fault the process undertaken by the MCI, but to ensure complete justice between the parties, having regard to the fact that doctor is 76 years of age, punishment was passed 10 years back. So in exercise of powers under 142, we have requested the National Medical Commission to reduce the punishment imposed by the Executive Committee and to issue a censure or a warning. And we have granted liberty to that effect. The appeal stands allowed to the aforesaid extent.
I'm okay.
Obliged.
This would not have been possible without your cooperation.
Your Lordship, my pleasure.
Thank you.
This, I know this is not the appropriate moment, but Your Lordship, in the peculiar facts, which so
142.
140.
140
Sorry,
will
my bad.
never be
My
appreciated.
mistake then. Obliged.
My lords, with your lordship's leave, just before Mr. Hansaria starts, I have a small request. My lords, I am away on a personal engagement. There's a wedding in the family, I'm away. But tomorrow, particularly difficult. If after Mr. Hansaria finishes, can I just have 10 minutes after he finishes?
It's
I've
all
just-
up to your colleagues on the
I've made that request to them as
other
well.
side, you persuade them.
I've made the request to them, as long as your lordships are fine with it. Very well.
But now,
There is no heat.
there is no heat generated now. We have. No. My lord is saying whether there is heat in the courtroom now, there is no. Please, your lordships.
We have to be very careful now in court
Yes, my lord. Yes.
because everything that we utter
Yes, my lord.
gets reported in 10 minutes.
Yes, my lord. Yes, 10 seconds, my lord.
Whatever happened in the first session is already reported.
Oh, that's why, my lord, the Chief Justice said it before the matter was called out. He said that media has to be, I want to say something to the media, that they have to be careful about what they report.
Yes.
Yeah. Lord, can I, my lord, request your lordship to take the compilation of documents, my lord?
Volume 2.
Volume 2, my lord. Yes, volume 2.
Identify by volume number.
Yes, volume number, my lord. Please, lordships. Lord, here first I want to invite your lordship's attention to the few meetings of the Constituent Assembly committees, my lord, and some Constituent Assembly debates as to what was the anxiety of the constitutional makers, my lord, the founding fathers. If your lordship kindly come to, my lord, page 3, which is part of the minutes of Fundamental Rights Subcommittee dated 29th March 1947. At page 3, clause 8.
Yes.
Clause 5 of Article 5 of Munshi's draft was taken up. The committee came unanimously to the following conclusion. Universal adult suffrage must be guaranteed by the Constitution. Elections shall be free, secret, and periodical. Now, 3 is important. Elections shall be managed by an independent commission set up under the Union law. Well, it's very clear, my lord. Now, lordship may kindly come to, my lord, next page, page 5. It is the minutes of the meeting of subcommittee on 17th April 1947, Minority Subcommittee. Page 130.
The judge of the Calcutta High Court.
Yes, my lord. And he was the Prime Minister of Jammu and Kashmir.
Sir?
Too. Yes, my lord. For a
He
short-
was also a judge of the International Court of Justice.
Yes, my lord. And before that, he was the legal remembrancer to the government of Assam.
Multiple hats.
And he was the person, my lord, who framed the first constitution, draft constitution. But we hardly talk about Sir B.N. Rao, my lord.
I have read somewhere that there's one ICS officer from Bengal
Yes, my lord.
who prepared the first draft. Nobody knows about it.
Sir B.N. Rao, he was an ICS officer, my lord.
Sorry.
He said that.
And the Sir B.N. Rao traveled all. And he traveled all over the world, my lord, for framing the first draft of the constitution. And I was also surprised, my lord, that he was made the Prime Minister of Jammu and Kashmir. But then he resigned. He said that my views and the Prime Minister view are on the or the King's view are at variance, so I cannot serve him, Maharaja Hari Singh. Then he resigned after a couple of them. But page 4 is the minutes of subcommittee meeting on minorities, and at page 5, clause 13.
Page 5, clause 13.
Yes, my lord. The election commission should be an independent quasi-judicial body. This is the committee meeting. Now, what is most important is the advisory committee proceedings at page 6, my lord, on 21st and 22nd April 1947, Lordship, may I kindly come to page 7, what Dr. Ambedkar has to say.
Page 7, yes.
Is a part of, my Lord, advisory committee proceedings of 21st and 22nd April, and what Dr. Ambedkar has to say. I must say, I attach a very great deal of importance to this clause of adult suffrage, and I do not think we can allow any exception to this. This clause 13 contains 3 fundamental propositions. Whether you fix the adult suffrage at 21 or whether you fix it at 18 or whether you fix it at 13 is a matter of detail, and that matter. Now 21 earlier, at 18 now we do not know whether it will go further down. I'm sure will be subject to consideration of the Constituent Assembly. When we pass, it does not
Come
mean...
to the second thing.
Yes, my lords. The second thing is important. The second thing is that we have guaranteed of this fundamental right that the elections shall be free and elections shall be by secret voting. It shall be periodical election. The third, we have not said that there shall be direct, there shall be indirect. It's a matter of consideration by other states. There may be different opinion. The third is important, Lord. The third proposition, which is fundamental clause enunciates, is that in order that the elections may be free and in the real sense of the word, they shall be taken out from the hands of the government of the day. Nothing can be more clear than this. And that they should be conducted by an independent body, which we may call an election commission. We have also given permission